Lawyers have more than 20 years combined experience in real estate law. The banks have lawyers, and so should you. The lawyers at Bilu and Bilu can help you modify your loan or apply for a short sale while they defend your case in court. Contact the lawyers at Bilu and Bilu today so you can sleep easy tonight. Your home is your castle. Trust the professionals at Bilu and Bilu to defend it for you. The law office of Bilu and Bilu handles foreclosure defense in Broward and Palm Beach and all 67 Florida counties. Call the law offices of Bilu and Bilu today at 954-596-0669 or visit us on the web at bilulaw.com. That's BILULAW.com.
And we are back. We have the Ask the Expert show here. It's going to be a little quiet this afternoon. Renee's not here. Renee's working on another show that we do. And today, I love doing today's show because Bilu and Bilu has been with us from day one. They are, and he can't say it, but I can. We don't want the bar getting upset with us. Let me tell you something. There's a few attorneys out there that do foreclosure defense. But I'm telling you, and you're going to hear today, we have the finest, probably the most respected foreclosure. And they don't just do foreclosure, but we're talking foreclosure here in the state of Florida. Not just Broward, not just Palm Beach. And I'm going to tell you something. I trust this guy so much. And I can sit back because I can just hand the mic over to him. Let me introduce you to my friend also, Gil Bilu of Bilu and Bilu Law. Hey, bro.
Hey, how's it going, Steve?
I love when you come on.
I love coming on. I love hearing my name on the air. It's great. Although we got to work on this video feed because I have a face made for radio.
Oh, no, you don't. You're fine. You're fine. And you know what? I tell you what I love is your passion. You cannot have as much passion as you do and not be good at what you do.
Absolutely.
So we're like so lucky. We're so blessed to have you. Where do you want to start at?
All right. So one thing I got to start with here. This is great. I had some great.
No one's running for office, is there?
Nobody's running for office. No. Too many skeletons in my closet. But what I wanted to tell you, for the folks that have been catching me on my regular segments since April, we had a trial in April that I walked out of. I walked into it thinking I had about a 10% chance of winning. Walked out of it where the judge had told us, "Hey, I'm going to give you 4 days to submit a proposed order for me, me for my motion to dismiss or for a directed verdict, of course the plaintiff for their judgment, and I'm going to decide."
Is that enough time? I don't know. Is 4 days that give you enough time?
4 days gives me enough time to write a brief, which is basically what this judge was saying. Like, here, brief all the issues for me, give me the legal reasoning on why you should win, cite case law, give me everything I need to hand you your victory today. And I did. I put a good 12 hours into drafting this thing. I had to kind of put myself in the mindset of a judge, which was cool. I went back to my my roots as an English literature major in undergrad and said, all right, I'm thinking like somebody else. What would they say? And we've been waiting and waiting and waiting and waiting since April 16th to get our decision back. And we called the judge and...
Wait a minute, she gave you 4 days in your first hearing now?
Her first hearing, she's busy. She normally doesn't sit in foreclosure, which actually was kind of a blessing because really she came at this with the approach of this is any other litigation under, for a breach of a contract. And what I have to decide is under the rules that we have in Florida, not the special foreclosure rules that some people would like to apply to these cases. We're going to decide under Florida law whether or not the bank has made its case or whether or not the defendants made their case. And, we had a couple of really great salient issues, and I'll get to that in just a second. But what was great, so we finally were waiting. My client's going crazy. My client's going, like, I got a plan for my kids to go to school next year. I don't know what's going on. I called the judge's chambers a few times. I certainly don't want to annoy her. I'm like, what am I going to do? If I file a petition for writ of mandamus with the appellate court, which anybody remembers their civil history, Marbury versus Madison, huge case in the 18th century, one of the big seminal Supreme Court cases from the 19th century. Writ of mandamus is a court directing a higher court, an appellate court directing a trial court or a government official to do what they need to do. Now, I know if I do that, the bank's getting their judgment because now the judge is going to be upset with me. So I'm like, look, just be patient. So
I'm going to ask you something real quick. when you go up against these banks, they have some of the most high-powered attorneys there are because they got the money to afford them.
Well, you would think so. And there are certainly cases like that. The vast majority of foreclosure cases, honestly, aren't contested or aren't contested very well. And look, it's an uphill battle to begin with. And I prepare my clients for that all the time. So, yes, while you would think that they'd be sending in these high-powered attorneys, it becomes cost prohibitive for the banks. Not that anything's really cost prohibitive, but they look at the bottom line. And if you have an attorney that's charging you $1,500 a file and is getting a successful outcome 95% of the time versus somebody that's charging you $450 an hour plus paralegal time and is only boosting your percentage by 4%, they're not going to go with that. So they're going with what we call the foreclosure mills. And I'm not going to name them by name, but everybody in the industry kind of knows who they are because pretty much all they do is foreclosure, or they have large dedicated foreclosure divisions. Now, it's not to say that there aren't talented lawyers, and I will tell you that in this particular trial, the lawyer I went up against did a really good job for the most part. He was not an easy competitor. I tell people that when we walk into the trial room, walk into the courtroom on the day of trial, I kind of feel like a gladiator. I know maybe puffing myself up a little bit, but that's really the attitude that you have to go in with. And really what happened in this case underscores that. So anyway, I was given 4 days to write an order, which is like basically the judge telling me, okay, write me a legal brief, tell me why you should win. The bank submits its judgment or the proposed judgment. And now I know if I'm waiting this long that it's not because it's not because the judge is checking the bank's figures. It's because the judge is going through my order, checking my citations to other case law, rearranging some of the things that I wrote, and really putting out a well-balanced, well-thought-out opinion. And on Friday afternoon, I got the news that that's exactly what happened. I was actually at lunch with a few other attorneys, and my paralegal sends me a text message. We finally got it in. We won.
Wow.
Fantastic. Yeah, I paid for a round of drinks on that one.
Your client had to be happy.
I spoke to him this morning. Look, he's happy. We'll get to that also in a second, because it's a little different for me than it is for the client, obviously. Now, what was great about this case was that I had a few grounds that I went in that I went in to win. Right. One of the big ones was standing. Is can the bank prove that it had the right to bring the lawsuit when it did? Well, the bank couldn't prove that, and I'm not going to get into all the specifics, but it has to do with the note and mortgage were owned by a wholly owned subsidiary of the bank who was actually bringing the lawsuit. Well, that's not good enough in Florida. And so that was great. And even if it had been good enough, it turned out the bank didn't prove that either. And that was good. That's good, solid legal reasoning. That's knowing the law. The other part of this order that came down, this was the most interesting thing, was that the bank, when they were presenting their case, right, they had to give evidence to the court. Well, the bank's attorney, halfway through his closing argument, all of a sudden realizes that he's never had his witness testify as to what the amount of damages are. Well, if he's not going to testify as to what the amount of damages are, the judge has no way to figure it out. And the reason this happened was really because I fought him hard in the courtroom, and I actually got their payment history, which is a history of all the payments made and how much money's owed on the loan, including escrow advances, attorney's fees, all these things. At first, I got the judge to keep it out. She allowed a little more testimony from the witness and decided to let it in. And I have to say the judge made the right ruling in this situation. But he was thrown so far off his game that he doesn't realize until halfway through his closing argument that he never had the witness say how much money was owed.
Oh, God.
So he asked the judge, he's like, hey, can I reopen my case? And she goes, no. And so what that really underscores, what's really important, it's not just knowing the law. It's also knowing what you're doing in the courtroom. Because really, the standing issue aside, by having this other issue addressed in the opinion, basically the trial court said, look, even if the bank did everything else right, we can't give them a judgment today because we don't know how much is owed. Well, that stops them from trying to appeal the case. That means that at the end of the day, that the bank is going to have to come back and file a new lawsuit and start all over again. Excuse me, they're not going to have the ability to come back to the court and say, hey, we want a new trial. Because what happens when a decision goes up to an appellate court, the appellate court treats two different parts of it differently. When they look at the law, they look at it what's called de novo. It's Latin, it's new. So they say, look, if the judge misapplied the law to the facts, then we're going to send it back for reversal, send it back for a new trial, whatever it is. The judge is looking at what the fact finder found, right? The judge in a foreclosure case, because there's generally no jury in a foreclosure case, the judge is a finder of fact. The judge is there to say what's what. Okay, how much is owed? Did they prove it? Well, if the judge is saying, look, as the finder of fact, I'm telling you that they didn't give me any evidence. I looked through the evidence that they got in. And from that evidence, I still can't figure out how much they're owed. They've got no chance. Even if they get reversed on the standing, they still didn't put in the evidence they need to put in, so there's no point in doing it.
Is that a screw-up on their part?
You know what? It's easy to be the armchair quarterback, right? Monday morning quarterbacking. I will tell you that my opposing counsel, I told him at trial that he did a fantastic job, and I was very sincere when I said
Oh, you're always sucking up.
No, I was sincere when I said he did a really good job. You know, he was... I don't know what he thought he was expecting, but they certainly sent in one of the better litigators. But, you know, when you're up there in the heat of the moment, it's really easy to forget something like that. If you know, I've gone back through my transcripts from trials and from hearings and things like that and been like, I can't believe I said that, or I can't believe I didn't say this. You've got to be thinking on your feet. And you know, what I was able to do, I credit that part of it to my trial tactics. You know, the first part of it, look, that's legal reasoning that hopefully most lawyers can figure out. But being able to do it in the courtroom is another story entirely.
Well, you're a litigator, bro.
I'm a litigator,
I mean, that's
exactly.
what you, and you're good at it too.
Exactly.
So that's what's really important.
All right.
Let me ask you. So what happens? We can't divulge any names or anything.
Right.
So now, what is the end result for your client?
So the end result for my client is, look, he's still trying to keep his house, and we're still trying to find.
How long has he been in this house?
Don't remember exactly.
Must be a long time. You got to think back.
Yeah. Right. Well, the lawsuit was filed in 2012.
Okay.
And we went to trial in 2015. So, you know, 3 years of at least 3.5, 4
She
years.
kept him in his house for 3 years.
At least. But he's trying to work it out with the bank. He went through some bad business difficulties, and I have to point out that the bank was sinking $1 million judgment.
Wow.
So this wasn't a little $200,000 condo or a $50,000 condo. This was a big deal. Now we're trying to work it out. Now here's where he stands right now. The bank is probably going to file a new lawsuit pretty soon. I don't know about pretty soon, but the bank is going to file a new lawsuit. In the meantime, you know, we are trying to work on a loan modification. We're trying to work on some plan with the bank to keep him in. So he's happy that obviously there's a piece of paper saying you have to move out in, you know, 30 days. On the same token, it doesn't solve the problem, and we're working with him to solve the problem, to either sell the house or to work with the bank on a modification. Now, we tried a modification, got rejected, but now we're in a different position. Now they have to start a lawsuit all over again. They might say, well, you know, rather than paying the taxes and paying the insurance on the property, it might now be worth our while to sit down and talk with this guy and see if something can be worked out.
It's not another 3-year process, though, is it?
You know, for his sake, I hope not.
Okay.
Honestly, you know, he's been through a lot. It's not easy on him or his family. And so I'm hoping that we can really get them to where they want to be. In the meantime, we've certainly knocked the bank back a couple steps, and that's important as well.
We're going to go to break. When we come back, I want to talk about these people who want to try to handle this themselves.
Okay.
They've never been in a position like this before. You know, I can save a little money. I could do it myself. We need to talk about that. So when we come back, more with Gil Bilu of Bilu and Bilu Law. And we also going to have to give your website address so they can watch us.
Absolutely. For a live tweet me during the break at GBilu on Twitter. I got my phone here.
He does.
Talks to my watch. I'm here to answer your questions. www.bilulaw.com. The BILULAW.com. 954-596-0669 is our office number. Call or schedule your appointment for a free consultation.
We'll be right back.
At the law firm of Bilu and Bilu, we can help you if you are facing foreclosure. Don't lose your home due to foreclosures by the bank or mortgage company. Call the law offices of Bilu and Bilu at 954-596-0669. You have rights and we can help you exercise them. At Bilu and Bilu, your first consultation is always free. If your home is underwater or you are behind on your mortgage and you're confused about what to do, we can help. Call our office today, 954-596-0669 or 1-877-BILU-LAW. That's 1-877-BILU-LAW. At Bilu and Bilu, our lawyers have more than 20 years combined experience in real estate law. The banks have lawyers, and so should you. The lawyers at Bilu and Bilu can help you modify your loan or apply for a short sale while they defend your case in court. Contact the lawyers at Bilu and Bilu today so you can sleep easy tonight. Your home is your castle. Trust the professionals at Bilu and Bilu to defend it for you. The law office of Bilu and Bilu handles foreclosure defense in Broward and Palm Beach and all 67 Florida counties. Call the law offices of Bilu and Bilu today at 954-596-0669 or visit us on the web at bilulaw.com. That's BILULAW.com.
And we're back. I tell you, I love having Gil on the show. Anyway, go to Gil's website because we're on live right now.
Right now.
Give me your website address.
www.bilulaw.com. That's BILULAW.com. Not only will you get to see my beautiful face as I'm talking on the show, but we've got a lot of great content there. So, you know, if you've got questions that you're too shy to ask, you want to do a little research on your own, it's a great place. We have a lot of great information there. It'll help you feel a little bit at ease. Or sometimes it'll help you give you the language to talk about when you come in.
I like your facts and your questions on there. There's some really good stuff on there. You know, there's people out there, believe it or not, who do not know what loan modification is.
Absolutely.
Tell everybody what loan modification is.
All right. So a loan modification is where you've either got behind on your payments or you're about to go behind on your payments, and you've worked out with the bank and you've disclosed your finances to them, and you've given them your finances, your tax returns, pay stubs, that sort of thing, and you have somebody at the bank reviews it and says, okay, we're going to lower your payment by doing one of the following things, or one or more of the following things, I should say: reducing the principal that you owe, reducing your interest rate, or by extending the life of your loan. And they will help people keep their houses, stay out of foreclosure, or come out of foreclosure in the event that, you know, they qualify. And it's a pretty basic formula that we use. It's gross income versus actual cost for the house, for house payments of principal, interest, taxes, and insurance. And, you know, I've talked about this on the show before, and one thing that we do that sets us apart, I think, from a lot of other practitioners and from certain organizations, NACA, is that we don't just tell people what a new payment will be. We sit down and we go, well, is this likely to happen? Because if your new payment's going to be $950, but $750 of that is going to have to go to insurance and property taxes, the chances of the bank giving you that modification are between, you know, slim and none. And I'm not going to waste my time. I'm not going to waste my client's time pursuing a modification that has no chance. We're going to work on some other options, be it a bankruptcy, be it a straight-up foreclosure defense, be it a short sale. You know, whatever it is we can do to help the client out, we sit down, we analyze the situation with them, and we help them out of it. Now, I know you wanted to talk about the people that go pro se, which is Latin for by yourself, people that represent themselves in court. And I know I've quoted this on the show before.
Do you see a lot of that?
Yeah, I have to come in and clean up those messes a lot.
Yeah, I guess so.
And now here's what happens. You know, one of the smartest things I've heard said about it. I was in Palm Beach County Court one day in front of Judge Oftedal, who runs the foreclosure division there.
I bet he knows you very well.
He knows me pretty well at this point.
He knows how you work too.
He knows how I work. He knows I'm
but
not
you know
messing
what
around.
you're doing.
Absolutely.
Okay.
So there was somebody representing themselves that actually had a really good case, and they'd managed to represent themselves for about 2 years, done a pretty good job. And he denied their motion to dismiss, and they have to file an answer, and they start asking him what they should do. And the judge says, look, I'm not allowed to give you legal advice. He says, but, so the guy goes, well, does that mean I should hire an attorney? The judge says, I'm not allowed to give you legal advice. I can't tell you to hire an attorney, but I will tell you this. You might have a good case here. And representing yourself is kind of like doing your own dental work. At the end of the day, it's going to hurt, and you're not going to be happy with the result. And I thought those were, you know, within the limits of what he's allowed to say from the bench, a very, very poignant thing to say. In fact, I got an inquiry this morning via Avo, which is a website. It's a forum that I answer questions on as well. And the question was, I'm giving up the house. Do I really need to hire a foreclosure attorney? And my answer is yes, 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 yes. Did I say yes? Why? Right? And, you know, we've talked about this on the show before. The danger is not just the foreclosure and losing the property, at least in Florida. Florida is what's called a full recourse state. That means that the bank gets a judgment for the amount of money they're owed. Interest, principal, escrow advances, attorney's fees, court costs, you name it. They throw it in there. They get a judgment against you. Well, it's all well and good if your property is either worth more than the judgment amount or you've got a bidder that bids high enough to get the bank paid in full. What happens when you owe $250,000 on a $50,000 condo? And we get the dreaded deficiency judgment. And what's a deficiency judgment? Deficiency, very simply, difference between what you owe and what the property's worth or what it sold for at a foreclosure sale. A bank, after that foreclosure sale, has 1 year to come back and to go to the court. Look, we're still owed another $200,000. Can we have a judgment, please? So here you are, getting your life back on track. You think you know what you're doing, and you've got some money built up in the bank. You've got some money in your bank account. Your mortgage lender goes in, gets a deficiency judgment, and now is entitled to take all that money from you. So even if you just want to give up the house, talk to an attorney. We can help expedite that process and help you get the bank to waive the deficiency. We can do that by way of a short sale. We can negotiate with the bank's attorneys in court. But if you do nothing, you're opening yourself up to a phenomenal amount of risk.
You don't even know what your options are if you try to do it yourself.
Absolutely. I mean, you can read what's on the internet, and you don't know what to believe and what not to believe. You have to come in and talk to a qualified professional. Same way you could go, if you have a rash, you can go on WebMD.com, but you're better off going to your doctor.
Exactly.
So there's actually something else I wanted to bring up, and this is the other side of the foreclosure sale. Well, what happens if somebody pays more money at the foreclosure sale than the judgment? And that happens a lot. We see it especially when a homeowners or condominium association foreclose on a property. And this is something that we've been helping a lot of our clients with as well. It's called a surplus. So let's say your homeowners association has a judgment for $10,000. And a bunch of bidding goes on, somebody bids $15,000, right? So now there's a difference of $5,000. The court will cut a check to the condominium association once they get the money. At that point, all your subordinate lien holders, so if somebody has a judgment against you, if you have a second mortgage, they have the ability, they have 60 days to come to the court and say, hey, we're entitled to some of that money. Once those 60 days pass, or if there's no other inferior lien holders, then the owner's entitled to that money. So, tragic situation. Family didn't even know that their HOA was
how would they
foreclosing.
even know that?
Well,
trying to represent themselves.
Well, that's kind of what happened. Somebody told them they might, and they came to see me, and they had been foreclosed on by their HOA while the bank was foreclosing on their mortgage. It was a nasty situation. I don't want to get into that part of it. But what ultimately wound up happening, there's just a pretty sizable chunk of money left over. And so what we're doing now, actually, I think this week, Thursday, if I'm not mistaken, I'm going into court. And guess what? I'm going to get them a nice chunk of change. Granted, look, they lost their house. They were losing it in foreclosure. They had to file bankruptcy. They came to me very late. But I'm able to now go in and at least make a little lemonade from the lemons and get a nice check for them from the court because their second mortgage hasn't come in and there was nobody else entitled to the money. It's just sitting there. I can go in and get it for them. They're pretty happy about it, and I'm pretty happy.
You know what I like about your firm? Now, you do bankruptcy, you do real estate, of course you do foreclosure, but you're not one of these boutiques that do criminal law and personal injury and everything. You really concentrate a lot on foreclosure. Yeah, we concentrate on foreclosure. We concentrate on real estate. We also do a fair amount of land use. We do real estate transactions. Commercial? Do you do commercial work?
I love commercial. Okay. Commercial is some of my favorite work to do. And I will tell you that, we limit it. We are actually, you got the terminology backwards. We are actually a little bit more like a boutique firm. We're a small firm. We're not quite big enough to be a boutique, but we focus for the most part on real estate. Of course, we do a little business work. Everybody does. It goes hand in hand with the real estate. I got into real estate back in 2003. I was working for a title agency. And I found that I really got to love real estate law. And I really wish I'd concentrated more on it in law school, but I've got my education now. And really, we do concentrate on all aspects of real estate. So if you're buying or selling, if you've got a problem with your property taxes on a commercial property, we generally don't handle residential. If you've got an issue with clearing. I just had a probate attorney contact me because they need to clear title on a couple of properties that were deeded into a trust incorrectly. And he said, you know what, this is above my pay grade. Or not above his pay grade, but not what he does. So he looked me up on the internet and he said, it looks like you really know what you're doing when it comes to this. Let me send these over. Take a look at it. You can do whatever corrective work needs to get done, charge the clients for it. And look, his clients are happy because they send it to somebody good. I'm happy because I got, because I get a new client out of it. We do quiet title actions, evictions for commercial landlords. Whatever it is you need when it's around real estate, we're in that sphere, and we're happy to do it. Bankruptcy a lot of times also involves real estate. That's why we entered the bankruptcy practice area. But I'm not going out and doing criminal. I'm not going out and doing any case. I'd love to get a great eminent domain case, but I tell you what, if you have a civil rights case, I will hand you off to a great attorney, but I'm not going to touch it with a 10-foot pole.
Okay. Well, we got less than a minute. Please give everybody your phone number.
All right. So
it goes by so fast.
It does. You can give us a call at the office for your free appointment, 954-596-0669. We could do it over the phone. We could do it via email if you have to. I've done that before. Or, of course, you can come in and meet one of us in person. Check us out on the web. It's www.bilulaw.com. That's BILULAW.com. And follow me on Twitter. I don't only post legal stuff. I do post a lot of legal stuff. Things about law. Everything I post is 100% legal, but you can follow me at GBilu. I'm on Twitter. I try to post pretty frequently. I post answers that I give to other people's questions. So, it's remember that book, Everything You Want to Know About Sex, We're Too Shy to Ask? Well, it's kind of what I do.
Gil will be back with us next month. Thanks so much for coming on. I love when you come on.
Thanks for having me, Steve.
Hey, we'll see you guys next week. Peace and love. We're out.
Thanks for tuning in today to the Ask the Expert show with Steve O and Rene. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program